Good afternoon, everyone. It's just at noon, so we have to make that change from morning to afternoon. Welcome to our fourth financial health webinar for 2021. So we have one more of these for this year, and we're really hoping next year in January we'll be able to go back to our Saturday mornings in person in the Health Conference Center. So that's the goal, and we're hoping that that will be the case. But we really appreciate you hanging in there with us, joining us via Zoom. We're coming to you from the auditorium in our West Tower here on campus. So I have our two presenters here with us, and we're talking to an empty room and to all of you via camera. So it's a little bit weird to get used to, but we're happy that you're here and you're going to get some great education today. I'm Sandy Vandenberg. I'm Director of Plan Giving here in the Foundation Office at Torrance Memorial. And I am so pleased to have the support of our Professional Advisory Council. They're a volunteer group of estate planning attorneys, financial planners, CPAs, professional fiduciaries, and those who are involved in helping people get their estate plans in place and to help educate the community about the importance of that and for some charitable tax planning as well. So we're happy to have their support and to be able to bring you these educational series. And we call this taking care of your financial health. That's also important along with your physical health as you do with the services from the hospital. So I emailed everybody who had registered yesterday with the link to the Zoom, and also the handout was attached. So you should have the handout of the PowerPoint today that we'll be able to review with you. If you would like a printed copy of that and are not able to print it yourself and would like that hard copy, please feel free to email me. And my contact information is at the end of the PowerPoint, and you can let me know that you would like a printed copy, and I'm happy to send that to you. So we will be holding all the questions until the end, and please use the chat feature of Zoom. You can find that at the bottom, about in the middle of the screen. If you click in there, you can submit your questions, and we will be recording those, and then Phil and Debbie will be answering those at the end. If you're not familiar with the chat and how to use that, feel free also to call. You can call 310-784-4843. 310-784-4843, and that will, Margaret will answer that phone and she will get your question written down. So thanks to Margaret and Alex who are in the control booth here taking care of all the technology for us. So your view on Zoom is something you control. You can click on the upper right to do gallery view or speaker view, so you just see who's speaking. So that is something that you can control on your end. Let's see, we will be recording this webinar and it will be posted on our website probably by the middle of next week. And I will email everyone who has been, who has used or has submitted your email and registered. I'll email everyone with the link of where that will be located. So if you want to look at it again or you want to share it with someone, it will be available for you to do that. We do have a couple other virtual events coming up. We always do our Miracle of Living series, and that is about health issues on August 26th. We're going to talk about the issue of cancer screenings. And then also there often are questions about Medicare, and our Torrance Memorial IPA does a Medicare 101 session. They do that monthly. The next one is on July 31 at 6:30 p.m. And you can go to torrancememorialipa.org and search on Medicare 101, and that will bring the details for you on that. So I wanted to share with you one of the highlights right now for Torrance Memorial is we are building a new building, a medical complex in El Segundo. And I'm very excited about that because I live in El Segundo, and it's great to have the Torrance Memorial name represented there too. So this is a rendering of the building that will be on El Segundo Boulevard. It's just east of PCH between Continental and Nash, kind of right in front of Raytheon. They had all that green space there, and so they sold a portion of that so we could put our building there. There also will be a Panera Bread and a couple other restaurants, a coffee place, and so it's exciting to see that happening. And you can see here what will be included there. We'll have an urgent care. We'll have primary care doctors, pediatrics, OBGYN, and that list you see here on the screen. And one of the great features too is that Cedars-Sinai, with our affiliation, has been very helpful in bringing specialists on to work here at Torrance Memorial. And they also are helping with this kind of building. So there will be office space also in this building for specialists to come and see people. So the drive to Cedars-Sinai is not much fun, and from the South Bay. So this will be a great opportunity for those appointments to be had right here in the South Bay in El Segundo. So I mentioned I'm Director of Plan Giving. Plan Giving are those gifts that are planned for the future. So they become part of your estate plan, whether it's an income generating tool like the annuity or a charitable remainder trust, or the most common kind of estate gift is with a bequest. Whoops, I did want to go forward there. So I do have just a few highlights there. We're talking about estate plans today and your trust and your wills. And so including some language in there to leave a gift to Torrance Memorial is one of the advantages. You can change your mind, you can revise it, you can update it anytime. And it can be a versatile type of thing where you can give a percentage, which is what's usually recommended, or a specific dollar amount if you want. And the estate tax is pretty high right now, so it's not needed for most, but it does help to avoid some of that estate tax as well. So and Debbie will be talking a little bit more about the wills and trusts and how you can include things in there. So anyone who includes us in their estate plan becomes part of our Heritage Society. That's the group we recognize those and appreciate them while they're with us for including us in their plan. So we do really appreciate if you let us know that you've done that, so we can appreciate while you're here. We have a website for Plan Giving. There's a lot of great resources there, different type tools and things that you can learn about. And there's also an online gift calculator there that can be helpful if you want to play around with those gift annuities and those kinds of things. And the other thing I always like to feature is this free estate planning kit you can download from there. It's an electronic record that allows you to put everything about your estate in one place. So you can put your family member names, you can get your accounts listed there, and everything comes together in one place. And so and Phil's going to talk also about a tool to be used for that, but this is another option. So we do always appreciate the support. Torrance Memorial is a nonprofit hospital. We've been very busy over the last year and a half with not only COVID patients, but others too. And so we do really appreciate all of the support we get from the community. So now I'm going to turn it over to one of our co-chairs. We have Christian Cordoba, financial planner, is co-chair this year with Grace St. Clair, who is an attorney. She's an independent attorney with offices in Redondo Beach. Her major areas of practice are estate planning, real estate, and general corporate law transactions. And so Grace is joining us from her office, and she is going to introduce our speakers.
Hi, everyone. Thank you for coming. Thanks this afternoon. It's good to see you all. So first, I want to make an announcement. This material is for general information only. It's not intended to provide specific advice or recommendations for any individual. We all know everyone's situation is different, so to determine what is appropriate for you, please consult a qualified professional. So today's webinar with Estate Planning Basics in 2021, we have two speakers today. I'm going to introduce Deborah Keesey and Phil Cook. Deborah Keesey is an attorney partner at Hanson Cito Keesey LLP with offices here in Torrance. She practices extensively in the fields of probate and trust litigation, conservatorships, estate planning, and business succession planning. In addition to California, Debbie is also licensed to practice law in Hawaii, where she first started her career. Debbie serves in several professional and community organizations, including the LA Superior Court Probate Volunteer Panel. She's also an avid squash player and badminton player and stays busy with her 3 teen boys. Also, we have Phillip Cook today. Phillip Cook is a certified financial planner who has been in business in the South Bay for 45 years. Located in Manhattan Beach, his firm Mogul Wealth Management provides investment management and other financial planning services such as retirement planning for individuals and small businesses. In those 45 years, Phillip has seen 3 real estate market swings and at least 10 general market swings, so he is well qualified to discuss the financial aspects of estate planning basics today. So help me welcome Phillip Cook.
Thank you, Grace, and thank you for joining us today. Much appreciated. Hope you learned something of importance and worthwhile out of today's meeting. So I'd like to know, as a general question, have you ever dropped a rock into a quiet pond and watched the ripples spread out? Having a child is a little bit like dropping the rock into a pond, in that there are ripples because of the birth of that child that last for years, and they spread far and wide. Also, the death of a parent or a spouse can do the same thing. The ripples created by that event can spread far and wide, and it can be difficult. The better prepared you are, the sturdier your boat, the better you're able to navigate those ripples, and I think you'll be able to get through the process much easier and quicker. After 45 years in the practice, I've seen a lot of things that don't work, and I want to help you. Hopefully, I can help you avoid some of the things that don't work. I was recently referred to a widow, and during the 53 years of their marriage, she never did a thing that had to do with finances, one iota. She didn't pay the bills. She didn't bounce a checkbook. She didn't do anything. You can imagine her consternation at the death of her husband, when all of a sudden she was the person responsible for all the for her financial welfare from that point forward. Trying to learn the mumbo jumbo of insurance or annuity claims, trying to understand income tax returns, trying to deal with the utilities when the account was only in one person's name, dealing with the register. In California, you got to get a smog check on your car every couple of years, and you then have to process the registration of that automobile through the DMV. Challenging for somebody who's never done that before, who's in a grieving period, and who has to learn all this stuff. It's a fairly steep learning curve, and fairly quickly you need to learn it to avoid mistakes. So another great example is two sisters, okay, siblings. They should be close, right? Well, only one of the sisters was named as the executrix and successor trustee of their parents' estate, and that created friction between the two of them that may or may not have been avoidable if two had been named. But I just hated to see them vow to never, ever talk to the other one ever again in the future. That's kind of a shame, because that's your family. Another example is, siblings fighting. Oh, I've seen siblings fighting each other in court because one of the siblings was in charge of helping dad, after mom was gone, helping dad as he got more and more frail. I can't imagine why somebody who needs help with the daily activities of living needs a new Mercedes, but all of a sudden dad had a new Mercedes. That seemed kind of strange to me. And the siblings also felt that was strange, and he was enriching himself at everybody's expense. And so they wound up in court. It's a shame to have to try to deal with all of these things at a time when you're grieving the loss of a loved one. And so you want to prepare. And to prepare, I've got a list of things that you have to do, you must do to be fully prepared. And the first one, the number one, is both spouses need to understand finances. They need to go together to meetings with advisors, whether it's their tax preparer, their attorney, their financial advisor, whatever it may be. Both spouses need to be involved. One spouse may catch on a little quicker or may know a little bit more, but you don't want to have somebody out there dealing with all of this financial stuff as a newbie, as I've never heard of it before at a time when it's difficult. Yes. Oh, yeah. Oh, yeah, yes. My PowerPoint. Sorry. Forgive me. Oh, yeah, that's okay. So why bother with estate planning? And I'll come back to the rules in just a second. Why bother with estate planning? Well, if you die intestate, means you don't have any direction, you don't have a will, you don't have any direction as to how to handle your estate once you're gone. The courts take over and they decide what to do. In California, the laws of intestacy decide who gets what, so there's an order to it, but you're not deciding who gets what, somebody else is. Do you want to pay thousands of dollars in probate fees and legal fees? Probably not, if it can be avoided. Do you want to risk your children, heirs, winding up in court arguing with each other? For California couples, Do you want your share of the community property assets going to the surviving gigolo or the surviving bimbo, the surviving spouse's gigolo or bimbo? You probably don't want that. You want it to go to, you want your half of the community assets to go where you want them to go. Do you want surviving spouse how to learn how to settle in the state, jumping through legal and tax hoops while agonizing on whether or not it's being done right? That's not a nice thing to leave somebody with. Do you want the settlement of your estate to take years? Again, probably you don't want that. You'd like it to get done as quickly and as inexpensively as possible. Do you want to leave money outright to a special needs child or to a child with a history of substance abuse? Probably not. Money outright in those circumstances creates consequences that you probably would prefer to avoid. And do you want to pay the maximum estate taxes possible? By the way, I should mention the estate tax is a separate system of paying for what the government spends. There's income taxes that are applied against what you earn, and then there's estate taxes which are applied to what you leave to somebody else. So you want to be sure to understand that's two separate systems, and they're not identical. The estate tax system is very expensive, so you want to try to avoid it. And we'll see more of that later. So these are, if you answer no to all those questions, you need to do some estate tax planning if you haven't already. Things to do now. As I mentioned, both spouses understand and involved in family finances. You don't want a 60-year-old or a 65-year-old try to learn how investments work or what insurance jargon means and things like that. So get some learning as you go. It's much easier, less stressful. Number 2 item is verify the registration of your assets. You want to be sure that the registrations are proper. If you say, well, I don't want to get a living trust, but I want my assets to transfer outside of probate, then you could establish an account registered as a transfer on death account. And you can do that with banks. You can do that with financial institutions. You can even do that with real estate. So you want to be sure that the registrations are proper for the outcome that you want to happen. I used to hear couples many years ago say, well, we don't need to do any estate planning because everything we own, husband and wife, everything we own is held in joint tenancy. And joint tenancy means in California, you don't have to go through the probate process. The asset automatically transfers to the surviving joint tenant. So there's no need for a court decision as to where it goes. Well, that worked really well, and that's true as far as it goes. The problem is after the first spouse dies, everything goes outside of probate to the surviving spouse, all well and good. But when the surviving spouse passes away, what happens then? Everything goes through probate because there's no surviving joint tenant. So you've got to be careful of using some of these, I'll call it, what will I call it? Homespun ways of trying to deal with a situation as complicated as estate planning is. Number 3, IRAs and 401ks. You want to verify 401ks, pension plans, 403bs, 457 plans, all of those types of retirement-focused plans. You have a beneficiary named on those plans. And so those assets don't need to go through probate because there's already a named beneficiary and on the contract. And so it goes directly to the beneficiary. However, things change over time. And you may not want the beneficiary you had initially appointed to continue to be the beneficiary. For example, that happens most often in the case of divorced couples. There's one or both spouses forget to change the beneficiaries on their retirement accounts and on their life insurance policies. So you want to be sure to verify that the beneficiary is current and the contingent beneficiary is current. Without a contingent beneficiary, or if you just don't name any beneficiaries, assets are paid to your estate. And again, not a good outcome. 403, I did that. What's next? Complete in the back of your package, you'll see a document locator form, and it's the last 2 pages printed on both sides. The document locator is very similar to what Sandy was talking about. That's on the Torrance Memorial website. But it's terrible to leave a surviving spouse not knowing where anything is, or leave your kids not knowing where anything is, and they've got to hunt and search for documents that they may or may not ever find. So this document locator tells you exactly where the will is. So I can, my heirs can find the will very easily. They can find the living trust if I have one. They can find all the important documents that you have, and many of them are listed there. So be sure to do that. The hour you'll spend will save somebody hundreds of hours of time searching for documents, and they may never find them. Number 5. Planning for end of life issues. If you've never spoken to your children or your spouse about how you want your life to end, then they don't know. And you need to start that conversation. And an easy way to do that is go to the Institute for Healthcare Improvements. They've got a program called the Conversation Project. And that program is on their website. You can get a book that will help you start the conversation. And it ticks off all the things you want to talk about and discuss. Slide. I'm on a slide. Sorry. I know where I am. Here's your document locator that I mentioned earlier. The one you have in the handout will have it on just one page, both sides of one page. Institute for Healthcare Improvements, the Conversation Project. The Conversation Project has a different website, and you can see the address of the website there. You go to that, you click on that link, and you'll get a booklet that helps you start the conversation with a spouse or a child or whatever loved one is important to you. And it allows them to understand what your wishes are, and then they can carry out your wishes if you're unable to give direction. Nobody wants to wind up as a Terry Schiavo sample, right? If you remember Terry Schiavo, the Florida woman, that was a sad state of affairs and lasted for years and years, fighting between the parents and her husband. So you want to be sure that everybody you care about knows how you want things to be handled. The other thing, one of the other things, those are the 5 things that you should do right now. And they don't take very much time, and they will help your loved ones immeasurably. If toward the end of life, you may have heard of hospice, and you know that's a process that a lot of people will go through when they know that they are terminal. It's important to understand what hospice is and what it is not. So it's medical care for someone with a terminal illness. And the idea is for them to live as comfortably as possible for as long as possible. There's a coordinated team of physicians and other caregivers that are working, that are coordinated and work together to take care of all the physical, psychosocial, spiritual needs for both patient and the family. And then care for symptom pain management and care coordination, communication, decision-making, clarification of goals for care, and the quality of life. All of these things are provided by hospice. And if you have Medicare, you have Part A, and Part A provides this benefit. It's called the hospice benefit. And so it's a great, great thing and can help people out a lot. When is hospice appropriate? When you are 6 months or less away from your demise, based on a physician's best estimate. A rapid decline despite medical treatment could be a lot of weight loss, could be mental status, inability to perform the activities of daily living. And you are ready to forego treatments aimed at prolonging life and receive care to live comfortably with pain management. So that's when it happens. And the last is, where does it happen? And it can happen at your personal residence. It can happen at the residence of a family member or close friend, in a hospital, or an assisted living facility, board and care. So hospice is available wherever you might happen to be, and it's a great thing. The hospice Medicare benefit, I mentioned that earlier. Treatments are not intended to cure terminal or unrelated illnesses, and the prescription drugs to cure terminal and unrelated illnesses are not covered with hospice. And room and board in a nursing home is not covered either. Medicare pays for very few days in a nursing home. Here's the estate tax rate over the years, and you might find this interesting. Back in 1997, a couple in in California could die. And as long as their estate was less than $600,000, they would not pay any estate tax. Now today, if that rule were still in place, you'd kind of laugh at $600,000. Here in the South Bay, anybody with a home, a retirement account, and some insurance is going to be over 600,000 pretty easily. So you could get hit with estate tax pretty easily, pretty quickly. The highest rate that you would pay estate taxes at back in those days was 55%. So imagine on a portion of your estate giving up half of it just to pay taxes. That's probably not why you worked hard for 30, 40, 50 years to build an estate. So there are ways to minimize that. And you can see that in 2002, it was knocked up to $1 million. And then we go to 2010, it got hiked up to $5 million. And in 2018, it's $11,180,000 per person. $11,180,000 per person. So a couple could avoid estate taxes as long as their net worth at this point, their estate was worth $23 million or less. So, and the estate tax rate has come down. The highest rate has come down to 40%. So how am I doing on time? Okay. Now, all of this is well and good because many people will say, and these rules across the country say that this is federal estate tax. I'm not talking about state inheritance tax. That's a different animal. But federal estate tax, not many people are going to be hit with federal estate tax. But if you are, it's very, very expensive, obviously. But in 2025, this $11,700,000 exemption per person is set to drop back to $5 million. And a lot more people will be in the estate tax zone at that level, especially with the way real estate across the country has appreciated. So you want to do some good estate tax planning so that your heirs aren't hit with these taxes. Choosing a healthcare agent, that's another thing that you want to talk about, you want to think about. How well do you know the person you want to act as your healthcare agent? I've got a great story for you in just a second. Is that person emotionally, geographically, philosophically able to carry out your desires? And legally, are they able to serve? Their age, their health relationship, the number of others already helping. All of these things play into this and have to be thought about. Also, cultural norms. Cultural norms may be different between the two parties. And if you're going to be with somebody 24/7, you better get along in a lot of different ways. I have a client, she's a widow, been a widow for, I don't know, about 20 years now. And she started needing in-home care. And so she's had 24/7 care to help her with activities of daily living. That's very expensive in California. So in order to lower her costs, she talked to a friend of hers who lives out of state. And her friend said, I'm retiring from my job. I'll come and be your caregiver and you can pay me. And what you would pay the friend caregiver would be less than what she was paying the agency for the other caregiver. So she retired from her job, left Utah, moved to California, moved in with my client, and was there about a week. It was so sad. They were yelling at each other when she left. The biggest problem, and I tried to warn her about this. I said, are you sure you really know this person that well? It was an unfortunate circumstances, and now she's trying to get back the people that she let go because she wasn't going to need them anymore. So you have to think long and hard about choosing a healthcare agent. Roles of a healthcare agent, what do they do for you? Medical care and treatment is one of the things. Interpreting advanced healthcare directives. Debbie will probably mention a advanced directive, otherwise known as a durable power of attorney for healthcare. Sorry, decisions for placement or to remain in the home, withholding medical treatment, access to medical records, moving out of state, and applying for entitlements or other programs. So that's some of the roles of a healthcare agent. And so you want to appoint the right person. And what happens if you change your mind? Well, you want that healthcare agent to destroy copies of things that are not applicable anymore. You want to tell someone, you want to make sure that they're notified, and you want to write revoked and sign all the documents, right? Revoked on the old documents and sign them so that you can make sure that there's no argument about which is the right one, which is active, which is legal. A doctor, Dr. Edwin Scheinman, sorry, wrote a lot about end of care, care at the end of life. And he developed a 10-point criteria for a good death. The next two slides, this slide and the next slide, contain those 10 criteria. And there's no comment from me, as it's your interpretation of what he thinks is going to be the most important part of these comments. So keep all these things in mind. Please, please, please do some advanced planning. It will save your heirs money. It will save them time. It will save loved ones a lot of grief. Thank you very much. Debbie.
Okay, hello, I'm Debbie Keesey. Thank you, Torrance Memorial Medical Center, Phil and Sandy and everyone who's helping us out today. I'm going to be talking about estate planning. And it's the legal side of it, but it isn't just about what happens to your assets, how to control that, but the other parts like the advanced directive, healthcare directive that Phil had just mentioned. It's all part of the plan, what to do when you're unable to care for yourself, what to do when you know, it's just too much to manage all of your assets, or when you're incapacitated, when you pass away, what is going to happen. So first I'm going to talk about some definitions, some concepts, and then all the documents that make up the estate plan. So we live in beautiful California. It's wonderful. And it's different than many other states. I went to law school in New York, and every time they talked about California, they would sigh and go, California, because our laws are quite different. We do things differently. And some of us really like it that way. So anyway, one thing to know about California when we're going to be talking about the estates and assets is that California is a community property state, which means, and I'll go into that in more detail on the next slide, but community property is going to have significance when you marry. Because that will determine if there's a chance for a divorce or there's a second marriage later, what happens to those community property assets. There are actually only 9 of the 50 states that are community property states. So it is kind of a unique thing. And like everything else, you know, the probate laws in California are very different, and I'll go over that too. Okay, here's some more definitions. As I mentioned, once you get married, things are going to be a little different. And so community property will characterize all the property which is acquired during marriage. So for instance, if one spouse works and earns all the income and the other spouse stays home, takes care of children, doesn't work a day in his or her life, all that income and the assets acquired during marriage is considered community property, which means it is half the wife's and half the husband's. Doesn't matter that one didn't get a single paycheck. Then there's separate property. Separate property constitutes all the property which you owned before marriage. So when you come into your marriage, it is still your separate property. It also includes any inheritances and gifts. Now, separate property can be what we call transmuted into community property, but you have to do certain active things to make it community property. You would change title, you would express it in a written statement, you would there are other interpretations when you commingle funds, but that's sort of beyond, I think, this presentation. And then when you own, say, real property in other states, they could be community property states, they could not. So anyway, we call that quasi-community property because if you have an estate plan in California, it's going to be governed by the California laws. But real property, if it's situated outside of California, still has to abide by those state laws. Okay, so now we're going to talk about probate a little bit. Everybody wants to usually avoid probate. I don't think I've heard anyone who was really wanting to go to probate except for creditors who are trying to get money back from the estate or the decedents. Okay, so I think Phil went over some of it, but I'm going to reiterate that, you know, probate is a very public process. You are going into court, you're filing papers, which are public records. So when you file for probate, you're going to have to list out all the estate assets as well as all the potential heirs. And unfortunately, you know, there are people who are going through those records and want to know who might be a target. Oh, I'm sorry, I didn't mean to do that. It's also expensive. You've got court costs, filing fees, attorney's fees, and executor fees. And it takes a long time because once you file, you have a 4-month waiting period where you have to publish in a paper so that all the creditors can potentially file a claim in that estate. And you have to allow them time to file their creditor's claim. After that, you have to file an accounting, and then you have a plan of distribution. So I think the shortest probate that I've seen is maybe 9 months. That's the shortest one. So, you know, there are other ones which have gone on for years and years because there's also litigation. So how do you avoid probate? There are essentially the following ways. You can hold assets titled as joint tenancy. So joint tenancy means that the joint tenants, say there's 2 owners, Phil and I own a bank account, we're joint tenants. With right of survivorship. So that means when one of us passes, the other one automatically by operation of law becomes the 100% owner of that bank account. And it doesn't go through probate. And that's a nice thing, but the joint tenant at any time, right, can withdraw and have access to all that money in the account. So it's something we always caution our clients about. Phil also mentioned there are transfer on death accounts and pay on death accounts, which also avoid probate. So bank accounts can be that way. Retirement accounts are that way. We never title them in a trust, but those have beneficiary designations. So upon the owner's death, the financial institution will look to that beneficiary designation to see who the account should be transferred to or the funds should be paid to. So you want to make sure that those beneficiary designations are up to date and make sure all your accounts have a beneficiary designation. If those accounts, even if you have a transfer on death account or pay on death account and there are no beneficiaries designated, then it will go into your estate and be subject to probate. And another way to avoid probate is to title your assets in a trust. And I'll be talking about that. And I failed to write down here, but there are a couple other ways where if it's a spouse who has passes, there's a spousal property petition that can be filed in court. So it's still court process, but not a full-blown probate. If assets, the aggregate assets that are left in your estate are equal to or less than $166,250 and don't include real estate that is worth more than $50,000, then you can use something called a small estate affidavit to get those assets transferred into the successor in interest or whoever is going to be the beneficiary. But it's kind of a low limit, so it's not available to everyone. Okay, so we're talking about what will happen after someone passes. Say you have a home, you have money, obviously. So here are the ways. So If you don't have a will, all these assets, right, there has to be a way, a legal way to get those assets which are titled in the decedent's name to the beneficiary's name. If you don't have a will, you don't have a trust, California has a statutory scheme where those assets will pass according to what they call, it's a chart of consanguinity, and it's a degree of relativity to the decedent. And it does pass sort of by the bloodline and 2 degrees depending on how far away that beneficiary is or heir is from the decedent. If you have a will, it also will go to probate. Some people think if you have a will, it will avoid probate. It doesn't. It still gets probated, but in your will, you get to designate what happens to those assets. It gets probated because those assets are still in the decedent's name. Now, if you have a trust and the assets are titled in the name of the trust, then you will avoid this court process because the trust, right, doesn't suffer the same death. When the decedent dies, or the settlor, the trustor, that's who we call the person who creates a trust, when they pass, the assets is already titled in the name of the trust. It will stay in the name of the trust, and then the trust will have instructions or provisions as to what happens after that person dies. Does it get paid out? Does it go to the spouse? Does it stay in the trust and get managed by a trustee for other purposes like education or things like that? The other vehicles I have listed again: pan death, transfer on death, and joint tenancy. So the advantages to trusts, of course, again, not only are they private documents, but they are basically your tool, your art piece, which you craft to be the way you want it. So you, of course, get to choose who will administer the trust, called the trustee. Initially, the person who creates a revocable living trust will be the initial trustee, but you will choose who will be the trustee after you pass. You will choose your beneficiaries. Even if you say have 3 kids, maybe you want, maybe you also want to leave some portion, 10% or a dollar amount, $10,000, to a place that you really have a lot of respect for, or you want to thank, like Torrance Memorial Medical Center. You may want to leave some to a friend. You can also craft it so you're leaving certain specific gifts to beneficiaries, like you can indicate like your engagement ring or your wedding ring will go to a specific person. And then remainder beneficiaries can split what's left over. And the division of the assets comes after all the debts of the estate are paid first, just to keep that in mind. And if you have minor children, maybe you want to do some other planning where upon both parents' death, maybe you want the trust to be distributed to the children in increments rather than all at once. Say as soon as you die or when they turn 18, because the idea is we want to encourage our kids to pursue their education. We want them to pursue gainful employment and not rely on the inheritance. So many of my clients will indicate that, okay, the trust will pay for the kids' education, healthcare, support, and maintenance. But when they reach, say, age 25, they'll get a third. At 30, they'll get the next third. And then at age 35, they will get the remaining balance. So you can do all kinds of things like that. Trusts, as long as the assets stay in the trust, by the way, the beneficiary's creditors will not be able to reach those assets. We call those spendthrift clauses, unless there have been some cases now where if one of the beneficiaries owes child support, then the courts can order that the assets that they are entitled to receive as an inheritance might be subject to that child support payment. Okay. Oh, and then finally, there are special needs trusts or special needs provisions in a revocable living trust that you can leave. So say you have one of your children is disabled or receives public benefits, you would want to probably include a special needs provision so that upon your death, these assets won't immediately go into that child's individual name, which might disqualify them from a needs-based public benefit. You would instead instruct the trustee to create a special needs trust for that particular beneficiary. Okay. Oh, and I guess I'll mention life estates also. You could say, this is your second marriage and you brought into the marriage or you paid for a house and you would like your surviving spouse to be able to live out his or her life in the house. But after that, you want that house to go to your children of the first marriage or something. You can design it any way you want like that. And sometimes, when we have a lot of kids, they have different needs at different times, or one might, become an artist and need a lot more support than the other one who became a financial planner or something like that. It's completely up to that family, but maybe the family wants to say, okay, well, all that money I paid out to help that starving artist all these years, I want to equalize it. And so when I pass, all that money, which they would have had to have some record for the trustee, will be considered in advance. And so there will be some equalizing distributions upon that parent's death. But who knows, maybe not. And that's when there's a lot of fighting that goes on. And then I get to go to court. Another document that's part of your estate plan is the will. And I did mention that if you have a will, it is subject to probate. But if all your assets are titled in the name of the trust, there's nothing to probate. But we make a will part of the estate plan because we consider it a safety net, because sometimes after people create a trust, they might still leave something in their individual name inadvertently. So they might open a bank account or, they do a refinance on their house where usually if you get a traditional lender, a bank, they will not fund that loan while the property that's securing that loan, they will not fund it if it's in the name of a trust, an entity's name. They want an individual name, someone to go after in case things go south. So they'll have the owners take the property out of the trust and put in their individual name, do the funding, and sometimes they'll put it back in the trust for them, sometimes they don't. And so anyway, there are all kinds of reasons that sometimes there are still assets left in an individual's name at death, even though they have a trust. So this will is like the safety net, and it tells the executor is the person who administers the will, tells the executor, hey, don't let this asset go into probate, Mr. Executor, Mrs. Executor. Instead, pour it into the trust and let the trust administer it. So it doesn't go through a full-blown probate. There's a court process to have that asset get put into the trust, but you're going to avoid all the main bad parts of a full-blown probate. Oh, and the other thing that a will is used for is if you have minor children, this is where you would nominate guardians to take care of your children's needs, and they can also control the finances, but you can also leave that power to the trustee. It does not have to be left with the guardians. Another document that's part of your estate plan is the power of attorney. Okay, so these next two documents, the power of attorney and the advanced healthcare directive, are documents that operate while people are still living. And the will and the trust usually are going, well, the will for sure is going to not take place until there's a death. The trust mostly upon death, but sometimes when there's incapacity. So the power of attorney, right, you will name a person, your attorney in fact, to make all the financial and contractual decisions for you. And you would want this in situations where you are unavailable or incapacitated. You've gotten in a car accident, you're in a coma, and somebody needs to get the money out to pay the medical bills. Well, this power of attorney will allow that. If you don't have one and there's no access to money, then there's probably another court proceeding. These powers of attorney can be springing or non-springing. That means if it's springing, it's not effective immediately upon the time that you sign it, but this is how we draft it, and it can be in different ways, but we have it so that when there are two licensed medical doctors, physicians, who certify that if it's my power of attorney, I cannot make these decisions anymore, then this power of attorney has effect and the person that I've nominated can make these decisions. If you have a non-springing power of attorney, it's effective immediately when you sign it. So you want to be careful who you choose. Usually when spouses create these estate plans, they will make reciprocal powers of attorney, and then you have alternates that come later if the spouse isn't available or has passed already. And the powers of attorney can be general, where they can basically sign anything and control anything, have access to anything, or very specific, like this this attorney fact is only going to have access to my Charles Schwab account, and it's written that way, and that's it. Okay, so the next document is the Advanced Healthcare Directive, which you've heard somewhat about. The Healthcare Directive is meant to be a guideline for the healthcare agent that you select. So on our healthcare directives, you will indicate what your preferences are, what you strongly wish. Things like, I don't want to be kept on machines if I have very little chance of recovering, or my quality of life will be very low. But this is done in consultation with the medical professionals. And it too can be springing or non-springing. Another part of the estate plan is the HIPA waiver. And the HIPA waiver, it has a short name. I almost never say it because it's so long. Health Insurance Portability and Accountability Act. And I can barely say it apparently. But this is the document that you want to have, which will authorize your medical professionals to be able to communicate your confidential medical information to the people that you list on your HIPAA waiver. So you will always want to put your healthcare agent on there, and then maybe family members and others who you've appointed as fiduciaries in your estate documents. And sorry, I'm ending a little bit early, but that is essentially your estate plan. The trust, will, power of attorney, advanced healthcare directive, HIPAA waivers. Oh, and by the way, even so, after you have created all these documents, don't forget to make sure your trust is funded. That means you need to title your assets in the name of the trust, except for the retirement accounts. Okay, so now I'm going to go to questions, and we have one already. Okay, so I'm going to go over here. So if you want to alternate, however you want to do that.
Want me to go first?
Yeah, you go first,
Okay,
Phil.
all right. One of the first questions we got is, I'll read it. Is there any tax on inherited real estate? And it was asked by a non-married partner. Well, depends on what kind of tax you're talking about. Are you talking about property tax? Absolutely, there will still be property tax on the property. If you're talking about income tax and capital gain tax specifically, probably not, because the property will get a step up in basis to the full fair market value. I know that sounds like gobbledygook. Basically, if you bought something for $100,000, that's your tax basis. If you sell it for $300,000, the difference between those two numbers, $200,000, is a capital gain that you pay taxes on. Now in California, we've got some exclusions for your sale of a personal residence by couples and or a single person. So there probably won't be any income tax or capital gain tax, because at the death of the first partner, you take a full step up in basis to the fair market value on the date of death. And so if the partner sold it shortly after the person passed away, there wouldn't be any gain. Are you talking about state inheritance tax? Well, in California, we don't have a state inheritance tax, but in other states, you might have some state inheritance tax. And last but not least, the estate tax. There possibly could be some estate tax on this asset when it is transferred to the surviving partner. Just depends on the values.
Okay, so thank you for the reminder. Sandy just reminded me to mention that I will be doing moderating a program regarding the conservatorship of Britney Spears on July 29th. It'll be free to everyone, and it'll be a Zoom presentation, and you can get more information from the LA County Bar Association's website. But conservatorships, basically, when you don't plan properly, when you don't plan properly, say you own a house and other assets, and you don't have a healthcare directive, and you don't have powers of attorney, and you say you get in a car accident, you suffer brain damage, or you are elderly and you develop Alzheimer's, and you don't have capacity, or you're very easily confused and susceptible to undue influence. Well, then your loved ones will hopefully come and say, let me help you, but they can't automatically just start taking care of your business. They can't sign for you. That's not legal. And if you've lost capacity, you don't have the capacity to sign a power of attorney at that point anymore. You don't have capacity to create a trust. So those people who want to try to help you have to go into court. And the proceeding is called a conservatorship, where they are asking the court to give them the authority and the power to make the financial and healthcare decisions for you. So for instance, if my parent is suffering from Alzheimer's and they don't know what, they get very confused, they can't sign any documents, but they do things like, this actually happened, a very expensive vacuum cleaner salesman came to sell my father a $3,000 heavy duty vacuum cleaner. And he signed the papers and everything. And, you know, they have wood floors. They had no need for this vacuum cleaner. Well, a conservatorship would help because it takes away his ability to make those contracts, to sign away money and to get in that kind of trouble. But it is very restrictive. So the courts are very, very careful. They make sure it's the very last and least restrictive alternative to helping take care of that person. So anyway, that's a little bit about conservatorships.
What is the difference between transfer on death and pay on death for a bank account? That is, how does the financial institution handle them differently? And Debbie, I want you to correct me if I'm wrong, but my understanding is that there's no difference between a TOD and a POD. It's the different name for exactly the same thing. And so there, it's one, you can use the terms interchangeably. And banks will offer TOD or POD registration, and financial institutions offer them also. The big advantage there is it will pass to the named beneficiary without having to go through probate.
Right, and I think of transfer on death accounts more like retirement IRAs, where you can potentially transfer them into an inherited IRA. And then the pay on death accounts are, for a good example, would be like a life insurance policy where it gets paid out on death. You're not going to transfer that one. Okay, so I'm going to go to the next question, which is, if a home was set up as a joint tenancy, I'm going to guess, for a husband and wife, does it have to be retitled as community property before putting the home into a living trust? The answer is no, you do not have to change it to community property. When you put it into, whenever there's a joint tenancy and then you change title, which we would do through a transfer deed, and we would say husband and wife, are transferring it to husband and wife's trust, it automatically severs that joint tenancy. And then it can go into the trust actually in any form. It could have been community property, it could have been tenants in common, but when you put it into the living trust, it becomes the trust property. And then within the trust, you can indicate exactly how it should be treated or characterized, whether it's separate property or community property, et cetera.
As long as we're on TODs and PODs, how often should I update beneficiaries for TOD and POD on accounts, even if not changing who was the named? Generally, you're going to change a beneficiary on a TOD or a POD account when some event happens. Maybe the person named as a beneficiary predeceases you. Maybe you get divorced. Maybe you don't like that person anymore. Maybe the relationship has changed. All of these things are generally event driven. And that's when you should go in and review all of your documents. When you say, this person who was my spouse, my best friend, my whatever is no longer in that position, I need to go and make sure that I've updated all my transfer documents.
Okay, the next question is, what happens if I forget to add some of my assets to my trust? And how can I be sure all are included? Great question. So at the end of the trust instrument, I attach a schedule of trust assets, but I make it as broad as possible. So I say all real property, including, and then I put the address of the house, all vehicles, all art collections, coin collections, all digital accounts and any other kind of intellectual property. So I make it as broad as possible so that everything can be included. And then if the client wants, we get a little more specific, including my, my Monet or whatever. So that's how I take care of that.
This is a great question. Any suggestions for couples where one does all financial things and other has no interest in learning? How can they best prepare? That's a tough one because emotion gets in the way a lot. But what I would suggest is painting a picture of what if I'm not here? How are you going to be feeling? What if you're going to wake up alone, for probably the rest of your life? I'm not here. And you are now challenged with handling all of this stuff. And you know nothing about finances, investments, blah, blah, blah. So how are you going to feel having to learn all of that stuff in a fairly short period of time at the lowest cost possible with the shortest bad outcome or the least bad outcome? So you can just paint a picture and encourage them and continue to encourage them. Don't just try once and give up. Continue to encourage them, and maybe every once in a while say, hey, that's a great lesson for us to learn. I just found out that our insurance policies are blah, 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 or whatever it might be that's financial, and try to weave that into the conversation. So by hearing it enough times and a number of times, the non-financial spouse will start to slowly pick up some information.
Okay, next question is, do non-titled possessions like furnishings, clothing, jewelry pass through probate if there is a will? That is correct. If there's a will or if there's no trust, then these items will go through probate and they're listed on an inventory, which there's an inventory and an appraisal. So a probate referee gets appointed to appraise all the non-cash items, and these possessions would be one of them. If you have a trust, as I said, you would say, the other thing I would say is all personal property. So if you have a trust, you don't exactly title, right? You don't have a title of ownership necessarily on your furniture, but you can include it on the schedule of trust assets for the trustee to administer.
Is it necessary to put bank accounts in a trust when you have joint accounts and or solid TOD beneficiaries? Why? I thought I pushed the button. I didn't take. So I'm sorry. Is it necessary to put bank accounts in a trust when you have joint accounts and or solid TOD beneficiaries? Why? A trust does a lot more than pass along assets. A trust can care for you and have a plan for caring for you when you are unable to care for yourself. A trust also can save estate tax costs. So there's a lot of things that trusts do besides just pass assets along, but most often they pass them along in the most efficient manner possible.
If a person is appointed a trustee, can they still inherit from the estate? Yes, so a trustee can also wear the hat of a beneficiary and they can inherit from the estate.
Married couple has single trust. For IRA, 401ks, spouse is the beneficiary. After death of the first trustor, should beneficiary of IRA, 401k, should the beneficiary of the retirement accounts be changed to the trust or to the children who are the beneficiaries of the trust. When you have a retirement account, as an IRA, Roth, SEP, simple 457 plan, you're going to have a named beneficiary, a primary beneficiary. You're also going to name contingent beneficiaries. So for a married couple with children, you might have the spouse as your primary beneficiary, and you might have the children as contingent beneficiaries. You might also have the trust as a contingent beneficiary, because the trust will pass along assets in the manner prescribed, whereas quite often, if you name a contingent beneficiary, it might be divided amongst them equally, and that may not be what you want. The most important thing is that if you do name the trust as a contingent beneficiary or as a primary after the death of one spouse, you want to be sure that it is what's called a see-through trust for IRA purposes, or for retirement plan purposes, because there are tax advantages that can be, children can inherit, non-spouse beneficiaries can establish an inherited IRA and move those assets in the retirement account over to that inherited IRA, and that gives them more tax planning opportunities. You can't do that with a trust unless it's known as a see-through trust, and it has special provisions where you could pay it to the trust and the children can still get tax advantages or tax planning opportunities through the trust. What else did I want to say about this? I guess that's at the death of the first spouse, though, you do want to review, obviously, all of your beneficiary designations and bring them up to date. You might then at that point move the deceased, obviously is not the primary beneficiary anymore, so you might want to move the contingent beneficiaries up to the primary beneficiary and then name a new contingent beneficiary.
Okay, here's a interesting question. My husband passed away several years ago. Our home is in both of our names as joint tenants. I was instructed to change the title. No problem. However, my husband had a grown son and I have a grown daughter. I prefer not to leave anything to his son. And my husband would have agreed, I only want to leave it to my daughter. Will there be a problem if I pass away and I have everything listed in my daughter's name? You know, litigators love this kind of situation. But okay, so if it's a true joint tenancy, then the survivor gets to control it. So the survivor, the wife, would get to do anything she wants with it, transfer it, keep it, sell it. Now, I guess, will there be any trouble? Possibly. I've seen a lot of cases like that. So, you know, but would it be a successful challenge? Maybe not, unless there can be tracing and, you know, well, there could be lots of circumstances, but, you know, including that the husband used separate property to purchase that one property, or that the husband was unduly influenced to change title to joint tenancy, you know. But I guess the straight answer, without knowing anything else, if it is a true joint tenancy, then the survivor gets to control it.
Can I find these documents online and fill them out myself? You could probably find anything on the internet, but it's important to remember that the internet provides you with information. It doesn't necessarily provide you with knowledge. So trying to get a living trust off the internet is probably not a wise idea. It's worth it to pay an attorney to give you some strategy and some options, and to give you all of the potential problems that can come about can be resolved. You're probably not going to be able to do that as easily with an internet document. But there's a website. It's called NOLO, N-O-L-O, NOLO.com, I believe it's the website address. And that's an organization that dispenses information, self-help books, and a lot of stuff regarding the law. So that's a place I would start if you're looking for these documents, and there might be a book to help you realize what you don't know by just looking at the form.
Right. And just one comment on that. You know, there are many and more online programs where you can do things like there's the, you know, it's a very standard power of attorney, for instance. But I have to also say that I have had more than a few cases where there was litigation because someone tried to create their own trust online and didn't observe all the formalities, or you know, there were other conflicts that basically invalidated everything that they were trying to do. Okay, so here's the next question. Oh, our research shows recently where that California laws have changed, and you now cannot do a transfer on death beneficiary on a property. Okay, so they're talking about you can do a transfer on death deed, which will also avoid probate if it's done exactly the right way. And as far as I know, you can still do one until January 2022, unless there's some legislation that extends it or modifies it in some other way. But as far as I know, it is still available to people until January 2022. And what you do is you have title on your deed, right, already, and then you record another, what we call a transfer on death deed, where you name the beneficiary. And there are, you know, there's a list of things that you have to observe and make sure that you get it right. If there are multiple owners, they all have to have identical transfer on death deeds. They have to be recorded. I think it's like within 2 months of execution and notarization. So there's lots of formalities, and I would say be careful. We haven't seen a lot of them done. We usually don't do them in our office because there are problems, but I know sometimes it becomes very, very useful.
Thank you, Debbie. I learned a little bit right there. Do you have to obtain or change new bank accounts when transferring your existing bank accounts into a trust? Yes, undoubtedly you're going to get a new bank account number, and you'll have to probably have checks reprinted. But understand that banks generally aren't that crazy about trust registered accounts, and they've been a little resistant to them. Over the years, though, they have gotten better as they become more familiar with trust. But be prepared. Your bank might give you a little bit of trouble about opening an account in the name of a trust. But most banks understand it better now, and they will do it. But you will wind up with a new account number, most likely.
Okay. There's a couple questions on what is the cost of an estate plan. So I think generally and it may vary, right, between downtown and say the South Bay, a small firm versus a large law firm and everything. But in this area, and my firm, we're between, assuming that there isn't a whole complex slew of other items like businesses that need to be transferred in, promissory notes that need to be dealt with, things like that. But generally, it would be in the range of $2,500 to $3,500.
Mention full step up in tax basis on death of first spouse. But what happens if property is titled as joint ownership and not in a living trust? The step up in basis is an income tax, or specifically a capital gain tax issue. And it doesn't matter how the asset is titled. You're still going to get that step up in basis if you are the rightful heir. Now, on joint ownership, we know who the heir is going to be. It's that other joint tenant survivor. But since the property comes to them and they sell the property, that step up in basis on the death of the first spouse is a real important tax saving item to pay attention. So you don't have to have it registered in the name of a trust to get a step up in basis.
Okay, if the majority of your assets are in another country, for example, Canada, what planning should we consider while residing in California? Yeah, that's a good question. So what, I guess, you know, when you ask an attorney a question, they come back with 10 more questions because they need more information. So like I would ask, well, how long are you going to be living in California? Do you own other assets? If you plan to live here for a while and you want to create a trust in California, I would list that Canadian asset on the schedule of assets, but keep in mind that the US does not have jurisdiction over assets held in other countries. So what my general advice is, you need to consult also with a Canadian estate a trust and estate attorney and see what that advice is. And, you know, unfortunately, you're going to have to get advice from two different attorneys unless you can find one that practices in both countries. So thanks.
Did you say that any assets in a living trust are asset protected? I did not say that. Generally, and I assume by asset protected, you mean protection from creditors. A living trust isn't necessarily going to protect you against any creditor claims. You might draft a trust in such a way to make it complicated for them, more complicated for them to get access to the assets or acquire the asset. But a living trust by itself doesn't necessarily protect you. Now, there are things called offshore asset protection trusts, and that may or may not protect you. Depends, from what I understand, on how the judge feels in bankruptcy court or in the creditor claims court. So, Debbie, if you have anything to add to that, please do so.
Okay, so I have this question. Is a power of attorney effective for only 5 years, and would it need to be renewed? Well, general powers of attorney can have a termination date. So it depends on your specific instrument. That power of attorney, if there's no indication that there's a expiration date, then it remains effective and does not need to be renewed.
My mother died, and as her sole survivor, I did not file probate. Is that a problem as she only had a bank account, not real estate? I'm going to assume this is all in California. In California, you don't have to probate an estate if it's below 155,000. Is that the number?
Yeah, they just increased it. It's 166,250.
Okay. So if the bank account was less than that number, 160 some $1,000, you don't have to go through probate, but you would file a short form probate. Because how does the bank know that it's okay to give you the account, access to the account? If you're not on title with your mother as joint tenant, then the bank has to have some kind of direction, and this short form probate form will give them direction that authorizes them to pay the money to you.
I am single and own a house. I created a California transfer and death deed a few years ago where my beneficiary is my partner and my sister. Oh, sorry. We ran out of time. No, you're right. Oh, I'm sorry. But I see we are also 1:15. Okay. Okay. I am single and own a house. I created a California transfer on death deed a few years ago where my beneficiary is my partner and my sister. Is that still valid now, or should I create a trust? Well, that's an interesting question because I was just looking at transfer on death deed legislation, and the consensus is that nobody knows what's going to happen. And there was a caution to check back when there's new legislation, either by January 2022 or around that time, to see what the legislators are going to do with these transfer on death deeds. So sorry, I don't have a good answer for you.
My parents had an AB trust. The lawyer said that this was a problem. Why? They still do AB trust. Now, first of all, for the audience, I'll describe AB trust. A couple in California I pushed the button and I don't look to see if it went green.
It's still red. It's still red.
I pushed the button, but I don't look to see that it went green, and so sorry. I'll start over again. My parents had an AB trust. A lawyer said that this was a problem. Why? Do they still do AB trust? Well, for the purposes of the audience who may not be familiar with AB trust, an AB trust is created within a living trust at the death of the first spouse. And the above ground spouse has the A portion and the below ground spouse has the B portion. That portion is, the benefit of doing that is it can be for estate tax purposes. And the other benefit is so that the surviving spouse can't dictate where the assets in the B trust go. You've already decided they're going to go to my children, whatever. And so the surviving spouse can't then say, oh, I'm going to take the assets in the B trust and give them to my girlfriend or my boyfriend or whatever it may be. They still do that today. It's not quite as necessary for estate tax purposes as it used to be because of the exemption I mentioned earlier of $11 million per person, but it's still a good idea to do that for dispositive purposes.
Okay, what death advance planning documents stop at death and which continue to cover final arrangements and accounts, right? So the power of attorney and the advanced healthcare directive become non-operative upon death. The will and the trust will, and the HIPA, sorry, the will and the trust will continue on and determine and help the trustee and the executor administer or distribute all the assets and take care of any. Oh, I take that back. The one thing the advanced healthcare directive does is it could indicate the type of funeral, burial, cremation, final resting place that somebody wants. You can also indicate that in your will or other documents. But other than that part of the advanced healthcare directive, it will basically become non-operative upon death.
It is green, so I'm good to go. Are IRA trusts available to protect assets? I believe the question is, if I have assets in an IRA, are they protected from creditors? And the answer is no, sort of, a little bit. Federal qualified retirement plans like a 401k, a 403b, a pension plan, are all protected by federal law from creditors. Okay, so if I had a claim against somebody for $1 million and the only thing they had was a 401k account, I could not get to that. So winning in court would do me no good. IRAs are not qualified retirement plans. They are tax advantageous, but they're not considered a qualified retirement plan. And as such, they don't have the same protections of federal law. IRA assets are protected by state law to the extent there is any protection. California does have some help in that regard, but it's not foolproof, not the way a qualified plan would be. One other thing I should mention is that if you roll over money from a 401k to an IRA, you have less creditor protection, but generally the amount of the money that you roll over is protected from creditors. Above that amount, it probably wouldn't be. It would go according to state law.
Okay, if a person inherits property after marriage, but the property was in a trust created before marriage, is the spouse entitled to half of the inherited property? Okay, so that middle part of the question, I didn't quite understand how property is in a trust, like a joint trust of the married couple. So I'm going to answer it two ways. So first I'm going to say, okay, if a person inherits property after marriage, all inheritances are separate property, and the non-inheriting spouse does not have any rights to that inherited property of the other spouse unless that inheriting spouse transmutes that property, like expressly puts in writing or expressly takes action to make it community property, like puts it in a joint bank account and intends for it to be community property. If there was, if this property was in a trust before marriage and it was of the two individuals, and so they have a joint trust, it's the disposition of that property would probably still be dictated by the trust instrument, whatever those provisions provide.
This one should be a fun question. How do I change or take out a car from a former trust? The car was part of the settlement to me. It also seems that my ex changed the name of the trust to his name only. Can he do that without my permission? I suppose you could find an attorney to rewrite the trust, but I don't think that that's a great idea for anybody to do. Generally, what happens is you're going to divide up the assets, and then the financial institution, before they take money out of a trust that has both names as the trustees and trustors, it has both names on there, they're going to want to know that they have the right to put some of the assets over here in this person's name and some of the assets over there in another person's name. And typically that refers to a quadro, qualified domestic relations order, and or a divorce settlement. So those documents would have to be provided to the financial institution before they would just start retitling things. If he got the trust rewritten, it wouldn't have any impact on your assets. He could just, when I take my assets out of this joint trust, if you will, and put it into a trust that's in my name only, then that's okay. That's what I should do. But to unilaterally change the name on the trust, I think that would take the signature of both trustees. Debbie, can you help me on that?
Yeah, I agree with that. Most trusts are designed, if it's a joint trust, both trustors who originally created the trust have to agree to the amendment. Either one can revoke it, but both of them would have to agree to any modification. So if the was it the ex created a new trust or put his name on it, I think that doesn't sound right. He either created a new trust or this is a different kind of trust instrument that I don't have familiarity with. Usually there aren't provisions which will allow just one trustor to completely change the trust and cut out the other trustor. For the, you said that you, or he got the, how do you take a car out of the trust? Yeah, or it was part of the settlement. I would think that the settlement agreement would have clearly laid out that, okay, this asset goes to this person A. And so you need to follow up and say, okay, here's the settlement agreement that you signed. And so now you need to sign over the transfer papers for this vehicle or whatever it is. Okay.
I need my trust updated. Do I need help? I'm going to suggest that you do see a qualified estate planning attorney to do that for you. And depending on how much updating needs to be done, how extensive that is, would probably determine what the cost might be. You might have to rewrite the whole trust, although I doubt it if it just needs to be updated. You might need an amendment to the trust stating the changes that have taken place to the existing trust. And Debbie, please.
Right. And I would just add, there are many formalities for changing trusts. So if you interlineate or handwrite in notes in the margins of your existing trust, those are probably not going to be deemed valid by a court. Okay, and I have just one last question, which is, can trusts with a no contest clause be contested? That's a great question. So, you can you can bring a lawsuit for nearly everything. Here's the risk, right? If you're successful, say you want to, maybe you're contesting an amendment to the trust that cut you out, right? So your contest, really, there's little risk because you're not going to get anything anyway. And if you get it invalidated, you're going to get a distribution. But say it's just a trust where you think there's no amendment, there's just one trust and you only get 10% while your siblings are getting 90% and you want to contest that. Well, the risk is, right, if you lose, you're going to get zero. If you leave it alone, at least you're getting 10%. So, those are kind of things that you need to look at. Also, there's probably a lot of other background circumstances that need to be analyzed by a trust litigator. What were the circumstances under which that provision, that amendment, or that trust was created? Was there undue influence or other things? Was there duress, fraud? Lots of other questions to be discussed. Okay, so thank you.
Thank you so much, Debbie and Phil, for the great presentation and all of those questions. Thanks to the audience for submitting those questions. A lot of good other information was provided for that. So I think, you know, we're all clapping. We can't see you out there, but we know you're all clapping for the great job Debbie and Phil did today. So, and if you did submit a question that we didn't get to, I will review what is in the chat and try and get answers to you if I'm able to connect your email with your name. Otherwise, my contact information is here. Feel free to email me separately or give me a call, and I will be happy to see that I can get some answers for you to those questions. So we did record this webinar, and it will be posted on our website probably next week. I will email everybody, as I said at the beginning, when it is posted and provide the link for that. And there's one more thing I wanted to mention. You know, getting your estate plan put together is so important to get it right. And so I do, as Phil recommended, to meet with a qualified estate planning attorney. And I wanted to highlight our professional advisory council list. It's posted on our website, and you can find it at torranceMemorialFoundation.org. If you look for the About Us tab at the top and open that up, you'll see the Professional Advisory Council. You can click on that. All of the attorneys, financial planners, et cetera, are listed there with their picture and a link to their website, which will provide all of their contact information. So it's a great group of folks here in the South Bay that we have vetted, and we know they're ethical and they do things right. And so please use that as a resource, so you have access to a good list of professionals, or give me a call. I'm happy to talk to you about that too. We have one more webinar this year. It's on September 10. It ties into the estate planning because it follows what happens after the person is gone, and it is the boot camp for the executor. So it's if you've been named as an executor or just want to understand what has to happen when someone dies and their estate needs to be settled. Professional fiduciary Ron Miller and attorney Grace St. Clair, who you met earlier, who did the introductions. The two of them will be presenting that webinar. So we are excited about being able to provide that for you yet this year. And then stay tuned for what will happen in 2022. We're in the process of planning for the webinar or the seminars, which hopefully will return to in-person on Saturday mornings. So thank you for attending. Have a great weekend and stay well.